Last Thursday, President Trump signed an executive order aimed at reasserting federal primacy over state AI laws. As you may have seen, the order directs federal agencies to challenge state-level AI regulations and threatens to withhold key federal funding, including broadband grants, from states that have adopted their own AI safeguards. The EO also establishes a new AI Litigation Task Force within the Department of Justice with the explicit mission of bringing lawsuits against state laws it deems to conflict with the federal framework. The Trump administration's stated goal is to avoid a patchwork of 50 different AI policy frameworks. While the aspirations for clarity in AI governance is understandable, doing so by executive order raises some important questions about constitutional authority, federalism, and the rule of law. That's what we're here today to unpack with some very qualified panelists. These issues matter not just for policymakers, but for families, workers, consumers, startups, and everyone else who relies on state safeguards and has an interest in AI. Over the next hour, our panel will examine whether this executive order can legally achieve what it claims to do, including what legal theories the administration is relying upon, and where we expect agency implementation to run into problems in the courts. To be clear, the executive order itself is just an instruction to agencies. The agencies will then have to take actions to implement them. Today, we'll be discussing how agency actions resulting from the order will likely fare in court. I'm going to start off by giving the panelists a quick opportunity to introduce themselves, after which we'll take some moderated questions. At about the halfway mark, we'll turn it over to audience questions. Please remember to submit your questions in the Zoom chat, and we'll line those up for panelists during the second half of today's press conference. A big thank you to our eminent panelists for being here today. And with that, I'm going to hand it over to each of the panelists to do a quick introduction of themselves. Charlie, let's start with you.
Hi, everyone. Thanks for tuning in. I'm Charlie Bullock. I'm a senior research fellow at the Institute for Law and AI, and I publish research and do some consulting on AI policy matters. I have recently published a piece doing legal analysis of some of the issues raised by the EO, and I have in the past done some work on preemption and things like that. So really excited to be on the panel today.
Great. Thanks, Charlie. Slade, over to you.
Hey, good afternoon, everyone, and thank you so much for having me. I'm Slade Bond. I'm the chair of public policy at Cuneo Gilbert LaDuca, a law firm in Washington, D.C. I primarily specialize on antitrust and consumer protection matters, but have quickly become an AI expert like many in this environment. Prior to that, I was the principal deputy assistant attorney general at the Justice Department and the chief counsel of the House Antitrust Subcommittee.
Great. Thanks, Slade. Jamie.
Hi there. Thank you for having me. I'm a partner at ACG Advocacy. I work on any number of tech issues, AI being one of them. I also work, like Slade does, on antitrust, consumer protection. I work on IP issues. Our firm represents many in the pro IP space, copyright holders and folks who create all of the movies and video games and films that we all love and enjoy. Prior to joining ACG a few months ago, I was Senator Marsha Blackburn's legislative director on the Hill and handled tech issues for her, including working on this issue when it came up in the reconciliation context. So thank you all for having me.
Thanks. Jamie, how much sleep did you get the night of reconciliation?
I think I was in the office for like 30 some hours, so that was fun.
Very good. Right. So those of you who've taken a look at the executive order realize that it has three components. One of them involves the Department of Justice and a litigation task force. The second involves BEAD broadband funding, and the third involves some instructions to the Federal Trade Commission. We're going to talk about each of these in turn because they each rest on a different legal framework or legal theory. Let's start first with the DOJ's AI Litigation Task Force. This is tasked with suing states over AI safeguards based on an interpretation of the Constitution's Interstate Commerce Clause. Slade, let's start with you on this one. What sort of precedent does this interpretation of the Commerce Clause rely upon, and how do you think it'll fare in court?
Yeah, so thanks so much for the question. So let's just take a quick step back and look at what the executive order purports to do. So it creates an AI litigation task force, as Doug mentioned. The goal of that task force is to assemble the greatest thinking at the Justice Department on whether or not different state laws violate something called the Dormant Commerce Clause, or otherwise raise questions on preemption grounds. So these are different theories for why a state regulation, an economic regulation, is discriminatory in a way that violates the Constitution. And this is not the first time the Justice Department has done this. I worked on several task forces at the Justice Department under the prior administration. This administration has already launched a task force that gets at this issue from the environmental law context. So it's not necessarily a new thing. What is new is that this is obviously an emerging area of technology in the law, and it is not one where Congress has passed its own law to either expressly or implicitly preempt a state law. And so what courts will look at and what the DOJ will evaluate when it's examining various state laws under the EO is whether or not there are ones that prohibit economic activities that are pretty much outside of the state, so discriminating against interstate commerce, or otherwise burdening commerce in ways that clearly outweigh the benefits of the state regulation. And I've conducted a review of many state AI laws passed in recent years, as well as the application of generally applicable laws. That's something I think Charlie can speak to as well. And generally, this is not an issue I've seen with many state laws. In terms of how challenges will be approached, I'd expect the DOJ to follow the similar playbook as Net Choice, which has challenged child safety legislation in California. But fortunately for consumers and Californians and people across the country, courts have rejected these arguments because the laws are generally non-discriminatory regulation of in-state conduct. And that's just a long way of saying that basically, to the extent that a state has passed laws on the subject of AI safety, they apply to in-state competitors just as much as they apply to out-of-state competitors. And there's more we can say on that topic, but I'll pass it over to Charlie for his thoughts as well.
Yeah, I guess just to clarify, the Dormant Commerce Clause issue is something that the executive order sort of hints at, but it's not the only thing that this task force could be doing. It specifically mentions the Dormant Commerce Clause thing. It specifically mentions state AI laws that are preempted by existing federal regulations. And it's not entirely clear what either of those things mean, but we can infer that the Dormant Commerce Clause thing is this argument that's been raised by Andreessen Horowitz's AI policy team, among other thinkers in the space. It has been written about extensively, sort of on the right. Personally, I think that the argument is quite weak, right? There's recent Supreme Court cases that make it really hard to do this argument that basically it's unconstitutional to have a state AI law because it has effects on out-of-state companies or something like that. The question is really whether it discriminates against out-of-state companies. So if there was a state AI law that said, for example, okay, in-state AI companies don't have to pay this tax, but out-of-state companies do, that would be probably clearly unconstitutional. But as far as I know, there are no state AI laws like that. So while there might be, there's a lot of smart lawyers at the Justice Department, and they may well find some laws that could be overturned. I don't expect that to be a successful argument with respect to the majority of the sort of important state AI laws that get talked about, California's SB 53, the Colorado AI Act that's been mentioned in this context, and so forth. So the big question that I think the Litigation Task Force raises is, will they be able to find other grounds on which to challenge state laws that are more meritorious? Because I think that one is quite unlikely to succeed.
Great. Thanks, Charlie.
And I mean, oh, sorry, Doug. I was
No,
going to
please, Jamie.
to say,
What are your thoughts?
sort of beyond the legal basis, right? Like this has been interesting to watch politically. Some of the media coverage has kind of made this a Republican versus Democrat issue, but obviously we've seen, Governor DeSantis, for example, chiming in. I believe Governor Cox in Utah has chimed in. Obviously, Governor Huckabee Sanders, I mean, from the beginning, she's been very, very vocally opposed to any sort of AI moratorium, and she, had led a letter on the Hill before in the reconciliation context. So, it's sort of curious, right? I mean, you probably would expect to see folks from, California and Colorado, which are sort of the stated targets, or at least had been sort of previously the stated targets. But, politically, there's some red state folks that get brought in here as well.
That's a great point, Jamie. And we're focusing on the legality and some of the constitutional arguments today, but The politics of all this, and particularly some of the 2028 presidential politics, are really interesting. I think one of the things that people have remarked upon is the way that people who are in the 2028 conversation, such as Governor DeSantis and Governor Huckabee Sanders, kind of see this as an issue where they may be choosing the side that is going to be really have the upper hand come 2028. On the Democratic side, you've seen some possible candidates like Rahm Emanuel stake out similar positions, focusing a little bit more on social media. But it seems to be there may be a trend going this way, and they're wanting to get in front of it. But we'll save that for another time. Jamie, I'm actually going to come back to you and talk about the second component
Sure.
of the EO, focus on broadband funding. So the EO contains a section. It instructs the Commerce Department to withhold non-deployed BEAD funding, quote, to the maximum extent allowed by federal law, unquote, from states with AI regulation. What do you have to say about this? Do you think this is legal? How have similar agency actions held up in court, if there's anything like this that has happened before?
Yeah, I think that this is very interesting. When this initially was framed in the reconciliation context, it was done a bit differently. Obviously, there's the overhang of things needing to be, get past parliamentary muster to get into the reconciliation process, which is its own sort of particular process. But the way they had framed it then, right, was there's sort of this extra pot of BEAD money, and if your state wants to access this extra pot of BEAD money for AI specifically, right, then you need to basically not have laws that would be sort of in their mind, overly burdensome, and you basically would, sort of forego enforcing the laws that would contradict. This is a little bit different, right? It's sort of a more broad set of conditions. Generally, it's not really the carrot and the stick approach. Um, I'm a little bit skeptical, right? I mean, I was on the Hill when IIJA was enacted, right? And there's very specific things that I guess they're calling it non-deployment funding now, but very specific things that the BEAD program looks to achieve, right? I mean, it is actually, broadband deployment, connecting anchor institutions, it's planning for broadband deployment. They do have sort of pieces that were more adoption focused, use focused. But at the same time, right, like you have to get the broadband actually there, which is what the program was intended to pay for. In AI, I mean, that's sort of an application, right? BEAD wasn't really meant as much for the application piece as it was for the actual infrastructure piece. So I'm a little skeptical here. I know Charlie did some good work speaking about like the spending clause, and I'll let him talk about that. But I on the face of things, right, I think this kind of goes beyond, um, what the administration can necessarily do without further action by Congress.
Yeah, Charlie, I'd like to go to you. Jamie mentioned the spending clause. I think that the two main constitutional theories that we seem to be implicated by the EO are the Dormant Commerce Clause and the spending clause. And I'd love to get your take on how the spending clause applies to the order pertaining to the BEAD funding.
Yeah. So first of all, taking a step back, there are actually two sections of Section 5, the funding part of the executive order. One mentions non-deployment BEAD funding, which Jamie just discussed. There's another one that implicates all federal discretionary grant funding that's sent to states, which is like, I don't know, $300 billion a year or something like that. And it says, all right, all agencies are going to get together with David Sachs, and they're going to look at all of their discretionary grant funding to states, and they're going to see if we can take any of it back if you regulate AI in a way that we don't like the federal government, right? So that to me is almost like more potentially worrisome than Section A, which is just about this $20 billion, still a ton of money in non-deployment BEAD funding. But yeah, there are questions about whether the federal government can do any of this. There are uh, first of all, questions about whether the statutes in question, that the statutes by which Congress allocated this money can allow for it to be used to pursue basically unrelated policy goals, right? There are constitutional questions about whether under the spending clause the federal government can do this. Can they basically, okay, Congress appropriated this money for one issue, right? Is it all right for the executive branch to take that money and do something completely unrelated with it without going back to Congress and getting any kind of authorization? Maybe, maybe not. It depends on things like what the statute itself says. Now, BEAD specifically, right, the authorizing statute for BEAD is interesting because when it was passed, and it was passed, by Democrats in large part, they included a lot of provisions saying things like you can't sue us saying that this violates the Administrative Procedure Act. They included a lot of provisions saying things like The NTIA, right, the National Telecommunications and Information Administration, the agency charged with distributing BEAD funding, can do whatever it wants. It's very broad discretion in distributing this funding. So there are all sorts of potential problems with uh, with the states' argument against the federal government's ability to specifically restrict this BEAD funding. But then on the other hand, there are very strong arguments. It just seems like a strange thing to allow the federal government to do, right? To say that the executive branch can take these billions and billions of dollars that have already been allocated to states by Congress, and it can do absolutely whatever it wants with them. It can use them as a cudgel to enforce any basically completely unrelated policy issue. And I've seen some analysis by Brian McGrail of the Case Action Fund, who was going to be a panelist with us today, but is having a baby, which we're all very excited about, so he couldn't be here. And his analysis indicated he thought that probably states would win if this lawsuit went to court, and I tend to agree with him. That's my initial sort of instinct, but it's a very complicated question. And I think that overall, this funding stuff is by a significant margin the sort of most potentially impactful part of the executive order.
Yeah, and Doug, if I can chop in on one point briefly, when Charlie called attention to all of the discretionary grants under 5B, that's a huge world of programs that exist for a reason. So as Charlie mentioned, this money doesn't come out of nowhere. Congress generally authorizes and then reauthorizes this funding through the appropriations process and otherwise. And it includes everything from protecting police officer safety to survivors of sexual assault, school safety and security, giving law enforcement resources and training and mental health services. So it really covers the gamut of issues that are really nonpartisan issues. Like, we should all want to keep our community safe. We should all want to protect sexual assault survivors and give law enforcement the tools it needs to do their jobs. And the idea that you would have a policy choice between AI deployment and development and these really important fundamental goals, to me, is incredibly immoral and wrong. And so the idea that you could hold that hostage or threaten to hold that hostage may be the point, right? And maybe the point just to create a chilling effect among states, particularly if they're in the early stages or are resource insecure when it comes to the exact type of things that discretionary grants get at. So I don't want to lose sight of that trade-off that's happening in this section.
Great, thanks, Slade. I just want to remind anyone in the audience, please put your questions in the chat. We would really love to, or in the Q&A, would love to have some ideas about what to ask after I exhaust the questions that I have prepared. And we specifically want to make sure that we're asking things that you guys really care about. Jamie, I'm going to go to you next. I know you need to leave a little bit early. We talked about the BEAD funding. Obviously, BEAD is an attractive pool of money for the administration to go after because it pertains to broadband. Broadband pertains to digital communications. AI is digital, right? You can see what they're trying to do here. The law, the infrastructure law that created the BEAD program was passed a few years ago. Obviously, the administration can really only target funds that haven't gone out yet. What is the status of BEAD funding currently, and why are we at a situation where you have this amount of funds that are still not yet dispersed?
Yeah, I mean, my understanding is that, and I think they've been very public about this, right? That early next year, the plan is to share more information about the money, which was about $21 billion that, has not yet sort of gone out the door, and how states can actually use that money. Back when the Trump administration came into office earlier this year, right, they sort of did a look at the money to, see sort of what it's being used for, how much of it has actually been used, and kind of did a full scale, a holistic look at it with the states. And so it does happen that there's, about half of it is still out there. And so that I know they've been, talking to parties sort of about how they want to use it. So, this is timely. I will say that I have clients, as now I work for a firm, right? And they're very interested in sort of what happens to the non-deployment funds. So, if to the degree that they're going to issue further guidance, I think that that is really a key question, right? Is, what are states going to be able to do here, and how does the EO that just came out sort of further condition what states can do with this money, right? I mean, for example, right, if you are saying, oh, we want to connect, this anchor institution in the state of West Virginia, right? Like, are there going to be conditions that sort of say, oh, well, West Virginia can't then use it to access this type of AI program, or, West Virginia, has to put a law into place that sort of regulates how anchor institutions can be, using this. We just don't know. So I'll be interested to sort of see how the guidance goes.
Thanks. It's funny how some of these laws, when they're passed, they have implications that this is the case with any law, but it's
Yeah.
relevant here that are you just don't quite anticipate. I remember some of the negotiations during the infrastructure law when there was a lot of talk initially about sending out the grants through the FCC and doing it on a sort of per capita
Yeah.
basis, population basis, and then for different political reasons. Yeah, the people who were negotiating this wanted to do it as grants that went to the states through NTIA, which really set up a system which can now be kind of leveraged for this political purpose, which is interesting.
Yeah.
I also think about the $21 billion, which you mentioned, which is a sizable pot of
Yeah.
money. A lot of us used to work in the Dirksen building. We probably have people from who are working in the Dirksen building today. And there's a quip from Everett Dirksen, right? $1 million here, $1 million there. And pretty soon you're talking about real money, right? Now we're talking about billions of dollars. The interesting part, which a lot of commentators have noted, is that, if you do the math and you figure what component of this $21 billion is going to go to different states, right? Obviously, larger states get a disproportionate amount because of their populations. However, their state budgets are also much, much larger, right? So we'll see this challenged in court, no doubt. If in the event that it survives a legal challenge, you would think politically that it would be much easier for the larger states, particularly some of the larger blue states like California, to say, we're not going to change our legislative prerogatives based on a few $1 billion in broadband funding that we can probably make up. But for smaller states that have smaller budgets, that's a harder trade-off to make. So the politics of this may play out in ways, again, that escape the initial planning by people who get involved in this. Slade, I'm going to come back to you. We've talked about the first two components as I laid them out of the EO. First, the DOJ AI Litigation Task Force. The second is the spending clause argument with BEAD. The third part, which I think is probably the least well understood, is the section of the EO that directs the Federal Trade Commission to issue a policy statement arguing that certain state AI laws are preempted by the FTC Act's prohibition on deceptive commercial practices. I know you've done a lot of work with the FTC. What do you do? How do you make sense of this? What does it mean?
I don't. It's challenging intellectually because it doesn't follow the law, and it's basically a policy objection. So the FTC itself does not have the ability to preempt state laws, full stop. And that is because when Congress created the FTC and when it gave it new authorities over the past century, it made clear that it did not intend the FTC to occupy the entire field of consumer protection or to gratuitously intrude on state or local enforcement activities. And that's why we have sort of a dual federalist approach to consumer protection in the United States, where states and the federal government both enforce state antitrust and consumer protection laws concurrently, right? So you could have, the state of Texas, as it has, really aggressively enforce antitrust laws in a particular area of the economy in a way that could be complementary or even duplicative of federal enforcement. And that's because when the DOJ is bringing a cause of action under the Sherman Act, it doesn't preclude a state's ability to do the same thing. So what does Section 7 of this order do? So it's asking the FTC to issue a policy statement about the FTC's Consumer Protection Authority, also called unfair deceptive acts or practices. And it does so in a way that is directed at something called laws that restrict the so-called truthful outputs of AI. And this kind of like raised my attention just because that's an interesting term phrase. But it appears to be directed at, like laws that are targeted at algorithmic discrimination and other areas that, theoretically a firm can pick winners and losers in our economy based on certain, immutable characteristics. And so that to me is an area where, there's nothing preventing the FTC from issuing a policy statement along those lines. But it, of course, would not be enforceable. There's very little it could do outside of its ability to bring ad hoc litigation under the same statute that would be, different than like a press release. So I think going back to my point earlier, and then I'll turn it over, I think this is really, again, this idea of a chilling effect. This idea that no, only the Federal Trade Commission is in a position to protect consumers, and states should not enforce their own mini FTC acts with regards to dangerous applications of artificial intelligence like chatbots and kid safety. And I don't know how persuasive that'll be, but to me, that has to be one of the goals.
Great. Thanks, Slade. I was surprised too when I saw the unfair and deceptive practices provision of the FTC Act mentioned. It made me think about, I feel like people have been trying to kind of shoehorn pretty expansive legal theories into that pretty much, the last few generations, and they typically fail. You kind of see them come from all directions because, on its face, those terms can be read to mean a lot. Jurisprudence has tended to narrow that, probably narrower than a lot of people believe it should be narrowed. But I think that is the set of precedent that we're working with, and it seems difficult to put this into it.
I'm going to be the one who thinks this is interesting. Sorry, I'll be the contrarian here.
Please.
Obviously the FTC has like fairly broad jurisdiction over things that are commerce, right? And their statutory language is a little bit broader than that, right? I don't have the definition pulled up. Hold on. Yes, I do. Right. I mean, they talk about unfair methods of competition in or affecting commerce. And I believe that earlier in the statute, commerce actually references, commerce sort of between the states. And so, traditionally, right, I think we do think of the things that they do as regulating, private entities. It's an interesting question, right? I tried to look back and be like, have they actually ever sort of done this vis-a-vis a state? I don't know that they have. But I think it's interesting, right? And we've obviously seen Ferguson sort of be pretty assertive in these areas, right? And I don't think that's necessarily a bad thing, right? I think actually we like some of the work that he's been doing. But it is an interesting jurisdictional question and one that I think is, at least to me, a little less clear than some of the other sections.
Okay. Thanks, Jamie. Charlie, I'm going to follow up on something that Slade just mentioned. He used the term press release. I've used that term before when people will talk about an executive order as being basically a glorified press release on better stationery because they always include the disclaimer at the end that it creates no new legal rights or obligations, et cetera, et cetera. But obviously, this is coming from the president to the administration and all the political appointees who are expected to put this into action. So we're going to see implementation. At some point, we're going to see action taken by the DOJ, the FTC, and TIA to create some kind of injury, provide some kind of standing for states to sue. What do you see kind of gaming this out? When do you think this will be actually ripe, or you'll have something that a state could actually have jurisdiction or have standing to file? Or do you think any states are going to try to kind of accelerate the process and find a way to get into court earlier than that? Curious to hear your thoughts.
Yeah, this is a really interesting question. It's one that I've done a little bit of thinking about. I still have more research to do. The obvious thing is, okay, if the DOJ sues you, then okay, now you're in court, right? As soon as the DOJ sues the state, can sue them back or whatever, right? And then there are questions of basically ripeness, right? On the what I think is the most impactful section of the executive order, the funding part. It's unclear exactly when states would be able to sue. Okay, is it when the executive branch announces that they intend to withhold funds from you? Is it after they actually release a policy saying, okay, you have a bad law and now we are withholding these funds from you? Is it right now, right? Because the executive branch, the president the Trump administration has already withheld non-deployment BEAD funds, right? Originally, these were allocated during the Biden administration as like, various ways of implementing BEAD that weren't just directly like putting in broadband, right? So maybe like cultural stuff or whatever that's sort of ancillary, but that would help the cause of advancing broadband equity. These funds have already been withdrawn by the Trump administration, and states did not sue about that. So there are questions about, when exactly you'd be able to sue on that. And then with respect to like the FTC Act stuff, I think that again, if there's just a policy statement by the FTC saying that your state law, we think it's preempted or whatever, I don't think that creates standing. I think it would probably be after the FTC actually undertook some sort of enforcement action or some sort of procedure for regulatory preemption that you'd have to sue. So as to when that will happen, like on the calendar, I couldn't say. Probably months from now, perhaps years from now.
Actually, Charlie, I had a question for you. To the extent you think there are applications of the executive order that can encroach on the constitutional process, like content-based regulation. So like going back to some of the goals of like anti-wokeness and AI, to the extent that they are targeting statutes that deal with, again, like anti-discrimination goals. Do you think that that creates a separate grounds for constitutional litigation or no, or just it's unclear?
Potentially, yeah. I mean, I think, I think that well, can you say a little bit more about what you're referring to? Like
Yeah,
what
no,
kind
this
of
is one of the things that's really grabbed my attention with the order and that line I mentioned earlier in terms of truthful outputs of AI. Like to the extent that the government through BEAD funding is engaging in, I guess, indirectly content-based regulation, like whether or not a state could argue that violates the First Amendment under a strict scrutiny analysis. Like if you think that would be a separate basis for a constitutional challenge in defense of, a state AI law along those grounds.
Yeah, potentially. I think you could raise that. But wouldn't you have to wait until after the federal government actually did something, actually took some action?
Oh, for sure. Yeah, no, there'd have to be some type of action for sure.
Yeah, so you're back to the issue of like when the federal government actually does something. I think probably not just the press release version, probably not just the policy guidance. I imagine it would have to be an actual like enforcement action of some kind.
And it does seem like a little more of the language about sort of the woke AI was put into the OMB document. So there was like a separate document that sort of came out right before the EO, right? And sort of talked about the use of AI by the federal government. And so it does seem like more of that language made it into the OMB guidance versus the EO itself. So to the degree that that matters.
I see a question in the comment actually about the FCC versus the FTC. Just to clarify, these are two separate provisions of the order, two separate sections. We've highlighted three of what we think are the most important sections of the order, including the one with the FTC. But there's also a section that the FCC, the Federal Communications Commission, has to, within 90 days, initiate proceedings to determine whether to adopt a federal reporting and disclosure standard for AI models that preempt conflicting state laws. So just to clear that up.
I'm very iffy on that situation jurisdictionally, I would just say, and then I have to unfortunately hop off. But I spent many years working at the FCC, and I think Charlie rightly noted, right? AI is not a telecommunications service, nor is it an information service, and so I don't necessarily know where the FCC is going to acquire the jurisdiction to do that. Plus, the FCC has over time always said, we're not an AI agency, right? Like this is not a thing that we are going to be regulating. So we'll see how it goes.
Great. Thank you, Jamie. And thank you for being with us. It does seem like one of the more interesting things that's coming out of this is a real focus on separation of powers, right? And this is one of the things that obviously preemption itself involves separation of powers under the Constitution. Which powers are appropriately granted to the federal government? Which powers are granted to the state? In what situations does a state take action that, burdens interstate commerce such that it steps outside the jurisdiction granted to the states? There's questions about federal courts to whether something is justiciable can actually be determined by that. And the EO in itself is funny. I'd like to give Slade or Charlie, either of you guys, a chance to opine on this. I think one of the first things that people noticed is, okay, they being David Sachs, some Republican leaders in Congress, tried to pursue AI preemption twice now through the legislative process. The first was during the budget reconciliation, the One Big Beautiful Bill Act in June and July. And the second was now through the NDAA, National Defense Authorization Act. Both of those attempts failed. Now you see an EO. The first reaction that I have, and I think a lot of people have, is, well, if you could do this by EO, then you would have just done it by EO, because obviously that's just much simpler. You don't have to worry about getting the vote, counting the votes, burning all the political capital on that. To me, that seems like that's it. That's all we need to know. Do you have thoughts about what am I missing here? Is there something more that's behind this?
Yeah, I mean, I guess I'll start off on this one. I think, yeah, this is a problem that exists not just obviously in AI policy, but much more broadly in the United States and our system of government. It's very hard to pass legislation these days. I think everybody knows that. And so, but you still want to do policy stuff, right? So you have a number of responses to this, but one of them is like, continually trying to expand the authorities of the executive branch when you're in control of the executive branch, and then complaining about the other party doing that when you're out of control of the executive branch, right? So during the Biden administration, we had the Biden administration trying to use the Defense Production Act to do these reporting requirements and have the Department of Commerce get reporting requirements from frontier AI companies and try to gather information that way. And Republicans were very upset about that. And now you have the FCC, right? The executive order says the FCC is going to use unclear what authority, but not even the Defense Production Act, something else to try to do basically the same thing, information gathering about frontier AI companies. And yeah, it's a response to the difficulty of passing legislation, but I think it's an inadequate response, like you said, right? It's not but at the same time, I think it bears noting that, it's not that the executive branch can't do anything. They can do some stuff. They're just much, much more limited than they would be with some kind of congressional authorization.
Slade,
Yeah,
what do you think?
sorry, go, Doug.
Yeah, I was going to ask you also, like, pulling this back, not just what happened before, but in the EO itself, right? One of the provisions at the end actually charges David Sachs and Michael Krasios, the head of the White House Office of Science and Technology Policy, with developing a legislative framework. So with them kicking it back to the Hill. What do you make of this?
Yeah, exactly. The one thing I was going to add to Charlie's piece is calling attention to some of the bipartisan opposition to the order. And Jamie was hinting at sort of elements of things that fell in or stayed in or fell out. And in the weeks before the letter or the EO was issued, there was a conservative group led by Mike Davis, Steve Bannon, and others raising significant concerns with the leaked EO along the grounds that we're not going to win the AI arms race the quote unquote Chinese way, which is by stealing and appropriating content and other things that are harmful uses of AI. And so I do think that's interesting, and it's clear there are choices being made in the order. Not clear totally why to me, but the one thing I would say, though, in terms of it not functioning just like a press release, is to Charlie's point about the many really intellectually gifted attorneys at the Justice Department. I'm sure there are laws in the books that are more akin to regulation of out-of-state contracting or price regulation or things that maybe would create a circuit split or other conflicts of the law around dormant commerce clause analysis. And again, like that's something that the DOJ, I'm sure, will issue an RFI and ask for industry and consumers to identify. But in terms of like using the crown jewel of the executive branch in this way, that's something that's uniquely concerning to me, insofar as this is negatively using agency resources, and in particular some of the best lawyers in the government. So the civil division will be one of the primary components of the Justice Department enforcing this, and maybe it's for the best that they're using resources on this and not other policy areas that maybe I and others disagree with. But the point is that this to me is not the best use of the Justice Department's energy and efforts, in addition to the concerns we have with it substantively. And then lastly, on the legislative front, I do want to express a word of caution on one item that stood out to me about the EO, which is this idea that it can include child safety protection. Congress can include child safety protections in a preemption bill, and that would somehow be okay. And I just really want to push back on that for two reasons. One is, even if you have perfectly crafted child safety exemptions, there is still an enormous amount of mischief that preemption can cause. For example, going back to the many FTC acts, and many being MI&I, states bringing an FTC act against an AI firm for some type of conduct that harms consumers, that could nevertheless be preempted by this language, even if it's not on its face about child safety. So that's concerning. And then the second and more pernicious reason is generally courts, when they see preemption coming from Congress, tend to side with Congress. I mean, I think there's a big toss-up between federalism in the courts today and Congress when it drafts preemptive legislation. So like airline deregulation is a really good example of that. And it creates perverse outcomes that are pretty much unknowable until the courts grapple with it. So to me, that's particularly dangerous, even in a world where Congress does act to legislate in this area.
Great, thank you. This reminds me, I'm one of the few people who's both a lawyer, a policy person, and also interested in Catholic history. There's a well-known story of Vatican I in the 19th century when the Pope at the time, the troops were advancing on Rome, and there was a great storm, and he locked the bishops who were there in the Vatican, and they came out with the decree on or the excuse me the council proclamation on papal infallibility, which has had people kind of scratching their heads ever since by saying, well, if the Pope is infallible, why do you need the council to declare it so? I had, it's not a perfect analogy, but then I had some questions here about like, okay, well, if the administration can do this on its own, what is the point of going to Congress twice and then also putting in here that you're going to go back to the Hill? So sorry if that was a bit of a digression, but I couldn't help myself. I'm going to turn now to some questions from the audience. Good question here. How does the executive order, and I'll throw these out, Charlie or Slade, whoever you think is best positioned to answer them. Uh, how does the EO affect state laws that already exist regarding AI, especially about AI and copyrights owned by creatives in the visual arts?
Well, copyright law is almost entirely federal. So the answer is it doesn't affect those very much because there aren't any. There are, for example, name, image, and likeness laws. Tennessee famously has the Elvis Act. That was the big deal during the moratorium debate. And so those laws, this is sort of a central question, funnily enough, about the scope of preemption. If the federal government preempts state laws in some way, for example, by this this litigation task force, which is not technically preemption, right? Nothing in the EO is actually preemption, but there's ways to try to get rid of state laws, which is directionally similar. So, for example, this AI litigation task force could, if they decided to, if under Section 4, the evaluation of state laws, they decide that these state name, image, and likeness laws protecting the rights of artists to their voices and stuff like that, preventing unauthorized commercial use of AI to like duplicate, whatever Taylor Swift's voice or something like that. In theory, the litigation task force could go after states for that. Now, I think there's some effort in the EO to send a message to red states, like, no, we're not going to go after you. We're just going to go after maybe blue states or wealthy states. We're going to go after the bad laws, not the good laws. But it's interesting to me that like there's not more explicit attempts to carve that out. Like during the last moratorium fight, there was an explicit attempt by Senator Ted Cruz to carve out the things that Senator Marsha Blackburn was concerned about, right? Being child safety laws and these sort of Elvis Act type name, image, and likeness and voice laws. And here there's very little of that. In Section 8, which is a sort of completely meaningless legislative proposal section, right? They say, oh, David Sachs can come up with a proposal for Congress, which is just completely advisory, doesn't actually do anything. And in that, we're not going to preempt state child safety laws, for example, and they name a few other things. But there is no mention in there of any sort of state name, image, and likeness laws.
Thanks, Charlie. Slade, please.
Oh, just briefly. I mean, there has been some litigation involving trademark dilution in the states, and in particular, there was a case involving Microsoft in New York. And this is like one of the cases we should look to when thinking about the Dormant Commerce Clause and sort of novel applications of state laws that maybe on their face are not about AI, but when applied to the types of things Charlie just described are very relevant. And in that case, a federal court followed the line of Supreme Court precedent that Charlie referenced earlier in the briefing to not find that to be discriminatory for the reasons we mentioned earlier. So that's an area that when we think about intellectual property rights and different ways that publishers in particular are looking to enforce their rights against illegal training of LLMs, that's something that comes to mind for me.
Thanks. I'm going to follow up on this. You guys both talked about what it mentioned in the EO in terms of types of state laws that are purportedly not being covered. And this is specifically not for the EO itself, but for the legislative framework that David Sachs and Michael Kratsios are charged with implementing. So they specifically call out child safety and data protections. I believe it's specifically with data centers, things like that. Question from the audience, if those are purportedly off the table, and obviously there's significant questions about how that's even done, which you alluded to, Slade, what types of state laws remain, did the president have in mind in drafting this that he would actually charge them with providing a framework for? What's left?
I think it's like a question we couldn't know the answer to unless we saw the legislative text. But I think we should go back to the Cruz Amendment that Jamie worked on from her time in Congress as a good example of like what a child safety amendment might look like or exception might look like. And I'll just say in that context, it creates all sorts of questions and opportunities for any defendant to litigate, right? So to the extent that a state is enforcing a law that could arguably be preempted in any context, any defendant, not just an AI firm, can bring, an AI firm with standing can bring a cause of action to challenge that law. And so I would expect this to invite well-capitalized corporate defendants using this as a different basis for challenging different state action. And so I think on the child safety piece, I'm incredibly skeptical that any exception for child safety laws would actually be adequate. I think it's very hard for Congress to preempt some, but not all, applications of different laws that have the benefit, the effect of helping children. And maybe there's a way to get at it by distinguishing between purpose and effect. But even there, I think it invites litigation risk. I welcome Charlie's thoughts on the data center question. I haven't seen language that I think would effectively get at this issue just because, again, this is a fairly novel area for Congress to legislate. But I invite Charlie's views on that subject to the extent he has any.
Yeah. As for what laws would be left, I think the primary laws that the executive order sort of like purports to be targeting are like so-called algorithmic discrimination laws, like what Colorado passed, right? Colorado's bill. It no longer specifically singles out SB 53, which is California's transparency law, right? So that's sort of an AI safety, like transparency about frontier models, what the risks they pose are and so forth, basically asking companies to produce information. It no longer specifically singles those out, but it's, I think, probable that the executive order would still involve going after those types of laws because they've been targeted by, David Sachs and the other people who are going to be involved in this process of figuring out which laws are bad in the past. As far as data center stuff goes, specifically, like it strikes me as like quite odd potentially that you would try to go after state like permitting laws for data centers and so forth, because these are just such local concerns, right? It is, it makes some sense to say that in theory, at least, that we're going to preempt state laws related to like the development of frontier AI systems or something like that, because that is pretty interstate, right? It involves the internet and stuff. Like you create ChatGPT in California and then it, is distributed to all different states. But like something about like how data centers in Virginia are permitted or something like that just seems like a very local issue. So I think it makes sense that they're saying they're going to not preempt those laws in their legislative framework. But yeah, I'm not quite sure what is meant by other than generally applicable permitting reforms, which is the language this Section 8 uses. Are they saying they are going to preempt generally applicable permitting reforms in the states? That would be odd to me as well. But yeah, a lot remains to be seen on that.
Great. Looking at the deadlines that are identified in the executive order, I see 90 days over and over and some other timelines. What can we expect? When can we expect things to start moving? What do you guys think is going to be actually the sequence of actions here?
Yeah, so going back to the other example of the Trump administration targeting what it viewed as conflicting patchwork regulation. So in the context of state Superfund laws, it took the administration several months to issue an RFI. So I think it issued it in August 14th, requesting information. This was from the DOJ, requesting information from the public on identifying different state laws that had a discriminatory effect. So that's certainly something the DOJ could do again. And then it filed lawsuits against Hawaii, Michigan, and several other states. And these are still very much in the ongoing litigation stage. I would say with that executive order, it has not been as effective as folks who opposed it feared. And these different cases could generate conflicting results. But again, I think the primary goal of it was not necessarily winning in court so much as winning when it comes to states making different choices around competing policy goals. So going back to the chilling effect on state activity, it could be the case that a legislature. So we're coming up on all these different legislative cycles in the new year. and legislatures take something off the table because of litigation risk or uncertainty, or other concerns, going back to the conversation we had around discretionary grants, et cetera. So I think that's something that can be happening very much in real time. And so we could, be 4, 5, 6 months before we see a lawsuit. But in terms of states making these competing policy choices, that could be happening in the next few months.
A question here about OMB guidance. We focus thus far on the executive order, but OMB has also put out guidance on AI. They put out more guidance last week. I think a lot of us saw this at first and thought it was the EO, and then said, no, it's not the EO, but then the EO came later. Do you think that the OMB guidance will be more legally enforceable than the EO with regards to quote unquote woke AI? And corollary question, the OMB guidance just applies to the government agencies and not to private sector and states, correct?
I'm nodding, but I was wondering if Charlie might want to take that one. I'll answer at a high level. So we're getting very close to saying EIEIO accidentally with all these acronyms. But with the OMB, it of course can issue guidelines for the federal government when it comes to procurement, and that's nothing new. I think this is an area where it could be constitutionally fraught to the extent that there are, protected categories of people who would not be able to, obtain a government contract on the basis of purported ideological differences with the government. So, like, to the extent that there is an AI platform that is not quote unquote ideologically neutral, does it have standing to sue the government because it's not using its AI tools? I have absolutely no idea. I think this is more, again, like a signaling policy. And to the extent that agencies are, going through the process of assessing different AI applications they may use, I can't imagine this is a systemic problem that needs to be solved. But that was my reaction at a high level.
Thanks. You mentioned EIEIO. Charlie, maybe hear you first, and then I'll save that for the next question. Charlie.
Yeah, as I understand it, the OMB guidance is basically telling agencies that are doing procurement, there's various reasons why a federal agency might want to use an AI system or purchase an AI system or pay a company money to use their AI system. It's telling them, like, okay, when you do this, there are certain requirements that you should impose in your contract with this company, basically to ensure that it's not being too woke, right? But the way woke is defined is actually, a little more nuanced than the signaling. It's basically saying, don't have super untruthful or like politically skewed results from the AI systems that you're using. And then, there's certain transparency requirements. They have to tell you if it's biased in some way and so forth. So that's the idea. And that does not really involve, as far as I understand, preemption of state AI laws.
Thanks. So it's late. I was saying your reference to Old McDonald and EIEIO had me. I immediately thought of National Pork Producers versus Ross, right? So it's funny. It's obviously on his farm he had a pig, a cow, whatever, and I've heard people this keeps coming up. And what can you tell us about what the Supreme Court's thoughts on the regulation of raising pigs in California might mean for?
That's so funny. I was wondering how you would connect EIO to the discriminatory applications of the Commerce Clause. But no, it's interesting because that was a plurality opinion authored by Justice Gorsuch. And it was hailed by some as being the death of the doctrine called the extraterritorial effects doctrine, which is basically, one of the core arguments that Andreessen Horowitz has made about why state laws that regulate the design of AI are unconstitutionally broad and burdensome. And so what was going on in that case is, I think a significant narrowing of the scope of the Dormant Commerce Clause in a way that's inherently supportive of state law. And so what's interesting is it has created somewhat of a circuit split in its wake. And so on one end of the spectrum, and these are the types of cases that Andreessen has cited to in their policy advocacy, but on one end of the spectrum, the Ninth Circuit and the Eighth Circuit have invalidated different laws dealing with drug prices. So in the Ninth Circuit, it's a pay-for-delay law, and the Ninth Circuit said that this is the unconstitutional regulation of out-of-state contracting. completely disagree with this. This is a bill that Doug's former boss, Senator Klobuchar, worked on the federal level. But that's one area where the Ninth Circuit basically revived this extraterritorial effects doctrine. In the context of the Eighth Circuit, in a case involving A.G. Ellison in Minnesota, there was a law involving price gouging of drugs. And again, the Eighth Circuit kind of pointed to the Ninth Circuit, said, well, gee, isn't that happening outside of our states? And aren't you really regulating drug transactions, so pharmaceutical drug transactions outside of state lines? And they found that to be unconstitutional. Compare that to the Seventh Circuit, which upheld almost a substantially identical statute and threw water on those other decisions, citing national pork producers. And so to me, it's pretty clear that the Supreme Court has said you really have to find some incredible argument in favor of why the law is burdensome, to the extent that it's not actually facially discriminatory and doesn't have discriminatory effects. And so I think this is something that's very much playing out. And it could be the case that to the extent that, net choice challenges some new AI law at the state level, that courts are persuaded by that. I will say, however, that so far they've been unsuccessful when it comes to child safety litigation. So one of the primary cases is Net Choice v. Bonta, where Net Choice invoked preemption and invoked the Dormant Commerce Clause. And the judge was very hand-wavy about it and said, you've only given me a page of briefing on this. That's not enough for me to find preemption or find that it's invalid under the Commerce Clause. And so what we can take from that is that there's some degree of uncertainty and risk, but that courts will want to see significant evidence in terms of how a state AI law might be burdensome. To me, and I'll shut up after this, to me, the other example to draw from are state protections around privacy generally, like biometric data laws, video privacy, phone privacy laws, and those have all been upheld. And so to me, it's like there is a tension on this issue. There is litigation risk and uncertainty, but it's been going in the direction of state rights as far as I can tell.
Great. Thanks, Slade. So we're coming up towards the end of the hour. I apologize to anyone in the audience who I didn't get a chance to ask your question. We had a lot of really great questions presented. Over 20. I got to as many as I could, but only a minority of them, just given the time that we had. So apologize if I didn't get to yours. We'll use the remaining few minutes. I'd love to give Charlie and Slade a chance to just make some quick closing comments, and then we'll wrap. Charlie, let's start with you.
Yeah, I guess the takeaway for me from this whole executive order thing is what's going to happen in Congress next. Because I think Slade and I agree probably that the executive order, it might do some things, right? It might have some chilling effect, but it probably won't have the effect of like preempting state AI legislation in any sort of broad or general way, right? It might have some chilling effects. It might discourage some state AI legislation, but it's not going to do any kind of broad preemption. So I think industry and libertarian-minded folks in Congress and so forth may attempt to continue to attempt to do a broader preemption of state AI laws. And I think it also remains to be seen what kind of substantive federal AI policy is going to be implemented, if any. So that is on the agenda for the upcoming year, for the upcoming legislative session and so forth. And I'm very interested to see how all that plays out.
Yeah, and just a short closing thought from me. To Charlie's point, I'm deeply concerned about any version of preemption in this space, and I think it makes sense to be mindful of prior experiences with preemption. So I'd reference the Airline Deregulation Act of 1978. But that has been uniquely harmful in terms of narrowing the ability of state attorneys general to bring meritorious cases. And it creates sort of a flywheel in that sense of states are not bringing enforcement action, laws are going unenforced, or they're held unconstitutional or preempted. And then it's putting pressure on federal enforcers to enforce every aspect of their laws in a very diverse, growing, nuanced economy. And I think that could not be more pronounced than here, where obviously the laws are developing slowly, but the technology is developing incredibly rapidly. So that's the first closing thought. The second is to the extent that Congress does act in this area, I would also be mindful of attempts to combine things that maybe are popular or have some appeal to them with preemption. And so this is something that's been played out in the House Committee on Energy and Commerce this past week, where child safety has been coupled with preemption language that would basically neuter a lot of the litigations that have been going on in this country to hold companies accountable where children die. And to me, there is no value in that approach where you're really, making a Faustian bargain on, choosing different values that ultimately creates winners and losers. I think that's a really poor way to go through the legislative process. So those are things that I'm mindful of, particularly in light of today's conversation, and things I'm watching for.
Great. We'll leave it there. Slade, Charlie, thank you so much for joining us. Participants, thank you for tuning in. We really appreciate your participation in this. On behalf of Americans for Responsible Innovation, please get in touch with us, ari.us, join our mailing list. Let us know if there's things we should be working on that you'd like to see. And we hope to see you at the next one of these. Thanks so much.